Okay, we are now live in Discord, YouTube, LinkedIn, and Facebook.
Welcome, everybody. I'm Samuel Martin. I lead the Virtual Civilization Initiative. We're all about human life and human freedom, and I'm proud to be joined by Matthew. Matthew, why don't you introduce yourself?
Thanks. Yes, my name is Matt Newsom, and I am an attorney. I started out my career as an IT/developer. So we might call that DevOps nowadays, but that term didn't exist in 1999. I launched my own web development company in 2001, and that was a lot of fun. In 2006, I started working for this cool open source company. We made a product called Ubuntu, which ended up being kind of life changing. I left there to start a company doing iPad app development and iPhone app development. That business actually crashed and burned, and it was a very interesting learning experience. And then after that, I went to work for John Deere. They make farm equipment, but what you might not know is they have a self-driving vehicle division. And so John Deere tractors have been autonomous since around 2000. And so I worked on self-driving vehicles and moved up. But that business that failed really inspired me to learn about what is it that makes businesses succeed and fail. And the answer to that question ended up putting me in law school because I became this really big passionate advocate for small business owners and successful businesses. And so now that is what I do. I run a firm called Iowa Business Lawyer. Actually, no, forgive me. That's not what it's called anymore. We're expanding outside of Iowa. It is now called Surge Business Law. And we only do one thing. You can guess from the name, business law. And I have a very dear place in my heart for technology companies. And so working with Samuel to answer some of the questions that this community has brought up have been exciting, very exciting to me. And so we talked about doing an AMA. I do like to have a little time to think about the questions. So he did collect a lot of questions in advance. Some more will pop up during the live stream, which is cool. I'm okay with that. But I do like to have good information, and so sometimes thinking about it helps me do that. And so the first 10 questions are on my slides, and I'll start working through them. So
Shall I go ahead and go with the first one?
yeah,
I'll give you a quick reintroduction. I'm going to do a short form video here, really quick. So, hey everyone, I'm joined by Matthew. Matthew was an ex-Google lawyer, and now he's joining us to answer your questions. We're going to jump right into it. So, first question, how do you approach the legal considerations involved in game development, particularly concerning intellectual property rights and licensing agreements?
I love this question. This is an excellent question from the community because it can really give me a survey of a lot of the different things that developers need to think about. So this particular question focuses on IP, but really I'm going to zoom out just a little bit. If you are just a person or a group of people, then you are either a sole proprietor or a partnership. And when you create something, you are usually creating intellectual property, very often copyrightable material, but sometimes trademarks or patents. If you haven't done a little bit of work to create some kind of legal entity, then the ownership of that information can be very confusing. In fact, I have a client, and he partnered with another person, and they took something that was already existing that he created, and they worked on it a little bit. And so now what happened? Did they create a derivative product? Does the new person own part of it? These questions can be very difficult to answer. In fact, I did another AMA where I answered a question that Samuel posed, and we specifically dug into this. And we worked on creating or talking through the concept of what's called a contributor license agreement, a CLA, where it helps make that more clear. But still, when you have individuals who have no organizational umbrella kind of covering what they do, then that intellectual property is very confusing. Unfortunately, global communities like P1, they have another complication, and that is that copyright and other intellectual property laws can differ quite dramatically around the world. Europe and America have laws that seem very similar, and yet there's important differences. For example, in some places in Europe, a creator cannot fully transfer copyright to someone else. But when you guys have an organization like a business that everyone's working for, it usually makes things simpler, because then this organization, whether it's a business or nonprofit, will own the intellectual property. That's not perfectly true, but it is true enough for most cases, so that one of the things that you might want to consider doing is creating some kind of legal entity. In North America, we have these things called limited liability companies that are very simple and very flexible, and they tend to make great organizations for businesses when they're still sprouting. However, when you start to grow to the point where you might want to get investors and such, then a corporation is usually necessary. At that point, you will usually want to have a lawyer involved, and the lawyer can convert an LLC into a corporation. But also, some people know from the outgo that this is what we're going to do. It's go big or go home, and so they'll start with a corporation initially from scratch. So one of the things that you want to do is you want to have some kind of organizational entity to coordinate and own the intellectual property. Then what you have to do, and this is going to give a little premonition to a future question, is you have to take these ideas that you guys have and convert them into some kind of fixed form. There was an interesting question, is an ice sculpture something that can be copyrighted? And the answer is yes. And you might say, well, that's such an odd thing that an ice sculpture could be copyrighted because it's going to melt in a few hours. But in fact, it can, because if you take this vision that you have in your mind of this beautiful thing, a swan or whatever, and then you carve it into a tangible form, even though it is a transient form, it's still able to be copyrighted. A balloon animal, if you twist balloons and shape them into an animal, that could be copyrighted, even though it's going to pop. That's fine. So one of the things you have to do is you have to turn your ideas into some tangible form so that they can be either copyrighted or patented or something like that. So those are probably the things that I would start with. But I will say that usually if there is a conflict, then it typically comes around either decision-making power or profit, or money, I should say. And so these are things that it's good to talk about in advance. And so when people come to me and say, "Hey, me and my friend, or me and my buds are going to start this business," then I say one of the jobs that I have is to ask you all of the hard questions now when you are excited and happy, so that later on, if you're ever mad at each other, then you can just look back and see what we wrote down after this conversation. But oftentimes, like, we see this with a 50-50 partnership with two people getting together. Well, one person says, "I think we should change," and the other person says, "I think we should stay the same." And then they vote, and it's a tie. And so the one who wants to stay the same wins. And this is a very frustrating experience if you're the one that wants to change. And so the ability to control decision-making power divides a lot of people. And then also, too, what happens with profits? If you make a little money, do you reinvest it into the business, or do you go on a vacation? And there can be very drastically different opinions on what to do with profits. And so usually we'll create a plan to help people figure that out. And I'm sure that a lot of you are at the early phase where you just think, man, making $1 would be amazing. It feels like it's so far away. But I hope someday that you're going to have lots of dollars. I always think of Flappy Bird as an example. Do you guys remember Flappy Bird from a few years ago? This guy, yeah, indie developer, just kind of, could you think of a much simpler game? And the answer is not really, right? There's like no buttons, no controls. The graphics were elementary. And this guy was making hundreds of thousands of dollars overnight because it just blew up. And he wasn't prepared. And if you guys remember, he got so frustrated by all the criticism that he just pulled the plug on it. And that's sad to me. So preparing for that, I wouldn't do too much preparation, but maybe a little bit of preparation is not a bad idea. So what part of that question is left unanswered? What could I go further on?
I really feel like a lot of people might not know the difference between an LLC and an incorporation. Maybe you could touch on that a little bit.
Yeah, sure. So let me just first of all tell you what the benefit is from a registered organization. This is true in America and Canada, and it is also true in many other countries that I am not as clear on their laws. But if you just go down to the end of your street and you put up a lemonade stand and start selling lemonade, you are what's called a sole proprietor. If your neighbor helps you, then you're a partnership. And that's fine. In America, you do not have to ask the government for permission to start a business. It can be one of those two. But a lot of times people want limited liability. And what that means is they've got their personal assets, their home, their car, their investments, whatever, that they want to keep safe from their business risks. And so if they get sued for something, they don't want that lawsuit to go after their personal assets. And so this business is formed to give them limited liability. The two normal ways to get limited liability are by forming an LLC or a corporation. LLCs are very flexible. There's a contract that defines the structure of the LLC, and so you can shape them into whatever you want. The corporations are quite opposite. They are very inflexible. There is rigid structure that is defined by law, and so you must do this, you must do that. So when it's just a couple people starting their game development company, an LLC is nice because it gives them flexibility. But if you are getting ready to invest, let's say you're going to put $50,000 into a business, you don't want flexibility. You want there to be enforced requirements to protect your investment. And so corporations provide 400 years, 500 years worth of law and lawsuits to define how they must work, and that gives investors protection. So when business ideas grow, then they will oftentimes go into that more rigid and structured format of the corporation.
Awesome. Okay, I'm going to put a quick pause on my recording so I can look down, because I can't look down unless I do this. If you guys have questions, feel free. I want you to hit the button in the top right corner and just go ahead and find that little chat bar and just jump in and throw in your questions freely. We're going to move on to the next one here, but I just want to make sure that you are free. And if anything about the answers to our questions confuses you, just this is your opportunity. Matthew loves to help people where they're at, and confusions are welcome, because that means we're solving a real problem at the level that they need to be solved, essentially.
I agree. And we do have another person watching on the other live stream. I hope it's not too boring if they can't hear Samuel talking.
Tell them we can drop a link or something.
Yeah.
I'll let you do that. All right. So I'll ask the next one here. Oh, we have somebody typing, but I'll ask the next one really quick. 3, 2, 1. What is the best course of action when you're getting new game devs to assist with the current project?
Yeah. So this is not so much of a legal question. There's a little bit of a legal element, but I worked for the Ubuntu project, and one of my jobs was to help coordinate a community. And I remember a lot of people would say things to me like, "Oh, Matt, it must be so cool working for an open source software company." And I said, well, actually, they give all of the cool work to the volunteers, and the stuff that nobody volunteers for, they hire people to do. And so one of my jobs was to coordinate a team of volunteers to help design and build the website ubuntu.com. And it was so fun. I loved it. But we had to deal with onboarding people all of the time. And so first and foremost, you want to make sure that you have your copyright stuff cleared up. And I gave an example of VLC. Does anyone here know what VLC is? Have you used that program? It stands for, I think, Video LAN Client. And it is basically a video player that can play any format, but it can also stream and do other things. They released an iPhone app to the Apple App Store. And some of the open source contributors objected to Apple and Apple's policies. And so they said that they did not authorize the use of the copyrighted code that they had contributed to VLC to be used on the platform. So they withdrew the permission to use their code. Well, they actually had the right to do that. That was within their legal rights. So what happened was VLC had to go through and remove all of their code of these objectioners from the VLC code base, and then recreate it kind of in a what we call black box development style, so that they could release it to wherever they wanted. In this process, they also created what's called a contributor license agreement for the community. So anytime somebody wanted to check code in through Git or whatever source control you use, before it would be integrated, you had to sign this contract called a contributor license agreement. It does not take away your copyright, but it does provide the community with a perpetual license to use it in an open source fashion. And so that means that once people contributed this code to VLC, they could no longer withdraw the permission. And so you will see now pretty much every open source project has this concept. So if you want to make a contribution, you'll sign a CLA. This is probably good even for organizations if they have volunteers and such, but they're not open source, because the same problem is going to happen. Now, if you have an employee who is making contributions, for the most part, all of the employees' contributions will be considered to be owned by the company. And so we call that in America work for hire. And so if I am an employee so I was an employee of Google, anything that I did for Google would be owned by Google. Even if I did it outside of my work hours on my personal laptop and it was for some open source project, I would still have to get Google's permission because they own me. And your employers might own you. So one of the first things that you want to do go ahead.
Go ahead.
One of the first things you want to do when onboarding contributors is to make sure you know that you have the right to use any contributions. And that could be documentation, graphics, audio files, software, whatever. And so a CLA or something like that is a good thing.
That's exactly why we hired you to get one, because we don't want that stuff that can happen with like what happened with VLC. So we're so glad to have you. Had such a good experience. Just wanted to bring you to everybody. So I really recommend that people just jump in, and if you need any help, contact Matthew because he does an awesome job. I can personally testify. So,
well, let me just say one more thing, that it's a good idea also to give a list of simple things for contributors to do. Now, this is me taking off my lawyer hat and putting on my software development coordinator hat. You should probably have some low-hanging fruit so that people can get used to it. And I think that's one of the best way for new contributors to get onboarded. But yes, now we're moving outside of the legal realm. So so let's go ahead and do the next thing.
Okay, so Pseudoscientist has a question. I should put my camera up. Pseudoscientist has a question. When a startup is barely beginning and doesn't have the upfront capital to set up an LLC, are there protections that you can take in the interim?
Sure. Excellent question. Now, what we do is we do a risk analysis. I learned this in high school. My brain just does this automatically now. This was just something that I learned, and that is what we do is when we make decisions, we try to do a risk versus reward analysis. And what's the risks of things that could go wrong? You're starting a business in your basement or garage or whatever, and you are hoping to hit it big, and you're going to launch to the App Store. And so you don't have any money yet. Is it worth doing an LLC? And I would say that if you are in pre-launch phase, your chances of actually something bad happening are very slim. And so your risk exposure is so low that I would say don't do that. And so if you start working on things together that, or if you start working on things and you start to realize, okay, you know what, this is it. This is the one that's going to be big. Then start looking for ways to get a little money into the business so that you can start your LLC or whatever, and then you get that limited liability protection. So pre-launch, I wouldn't sweat it too much. You're going to be deferring some problems and questions by doing that. Like, okay, well, it's me and my pal. We're both making contributions. I'm doing the game, and she's doing the audio and graphics. So who's going to own that? If it's just a small, couple people, it's going to be easy to deal with. So just push those risks on closer to launch.
I couldn't agree with that more. I'm not a lawyer, so I can't comment in any way, but I'll tell you that, in my experience, whenever I've led communities, if you set the right expectations from the start, that makes all of the difference. And one of the things we did here from the very get-go is we literally said, you're here to contribute. There's no money involved. And, that saved us so many troubles. And I would encourage you, have some clear expectations, because at the end of the day, that makes sure your friends stay your friends. And I've done so many projects in the past before I did, anything legally complicated with it. And I tell you, having clear expectations up front saved me so many times in a row. And I would encourage that. And I don't know what you think about that.
Communication is great. I think that's a good plan. So we have another chat, but there's two questions in one. Yeah. I think we should just do the first half of that question and save the second half for later.
So can game mechanics be patented?
Okay, and the answer to this is the lawyer's favorite answer, and that is it depends. And so I will tell you this, that it is possible to patent algorithms, and it is possible to patent certain kinds of mechanics things. And so I would say you probably have a good chance at patenting a game mechanic. And also too, I am very sorry to say, it is possible that the game mechanics that you've invented in your brain might have already been patented. And that is unfortunately a frustrating thing. So the answer is yes. Basically, the goal for a patent, it has to be a useful invention, and game mechanics do count as a useful invention. And then also too, it has to be it can't just be an idea. It has to be something that can be put into reality, I guess. And reality is such a ephemeral term here, because is software real? I don't know. Let's save the philosophy for later, maybe.
Let's say you draw the mechanics. Is that real? Does that count?
Yeah, and so that's how a lot of patents work, is they are drawn. And so you can even patent interesting UI designs. So Twitter patented the mechanic, the pull to refresh thing that you see on phones nowadays. And then they made a free license so that anyone can use it royalty free. And so everybody now uses pull to refresh, but that was patented by Twitter.
Interesting. All right, we have our next question from the audience. I'm going for the audience first. Is that all right?
I'm fine with that, yeah.
Okay. What about AI-generated art?
No, we got to do that one later, because it's already in the slides.
All right. Then we have the next one from Ryland that says, when an app makes money, what happens to the profits? Are they distributed among the team members? How does that work if there's like one person, greater than one person on the app dev team? Is it based on equity/ownership?
First of all, when an app makes money, we do celebrate. That's a requirement. I think that's even a law. And then the rest of the questions really is just one question, and the answer is yes, that profits are distributed according to equity. So there's a secret question in there, and that is, what is profit? And the profit is anything that's left over after expenses. And so oftentimes business owners will not have profits even after their first successful year, because they have a bunch of expenses in the past. And so if you go, let's just say it's two folks in their basement working on this for 9 months. Well, there might actually be some expenses that can be used to offset those profits, because you also have to pay tax on profits. And so a lot of businesses will look for ways to say, well, it's not really profit. And in fact, right, if you've been paying for cloud hosting and hired some graphic designers on Fiverr or whatever for a while now, you should be able to get paid back for that without having to pay tax on that money. And so in most places you can. But yes, it is distributed by percent equity. And so oftentimes what will happen is two people will start out and they'll say 50-50. And then when they're ready to grow their team, they will say, okay, the next people, they don't get equal shares, because early in, usually you took more risk and you should have more reward.
Absolutely. All right, we have our next question, which is, what do I do if someone steals my actual game code?
Yeah, let's see. Wait. Oh.
I did skip the NBA one.
Okay. How about, can we go by the slides just so we don't confuse?
Sure.
Okay, let's do this one.
This one you already covered, I think.
Did we? Can you copyright game design? Is copying game ideas okay? Okay, how about this? Yeah, let's go ahead and do this one too. I'll let you announce it because there's a
Okay.
couple things that we can add to this particular question.
All right. I'll just explain because I'm doing a recording, and I'll just 1 second. So we're just stepping back a quick question here, and we're asking the question: can you copyright game designs? Is copying game ideas okay?
Okay, so let me just first of all explain the difference between copyright and patent because the previous question was really about patents, and so copyright is basically some kind of creative idea. Patent is a useful invention, and they both start out the same way, but when they're translated into the real world for as real as we can ask for, then the results are different. A useful invention is patented, and then some kind of creative thing like a poem, a story, a song, a dance, a piece of art, right? Those are copyrighted. They might or might not be useful, so they might also be eligible for patent. And so, can you copyright game designs? And the answer is yes. The moment you put them into a fixed form, you automatically have a copyright. And so these slides, this is a creative thing that I made, and I know it's a work of art. You all agree. Um, and so I did these slides earlier today. The moment I took these from an idea and put them into some kind of tangible form, some kind of fixed form, then I received a copyright. Actually, that's not true because I did it for my business. So my business received a copyright for them. And so, yes, the moment you fix this into form, your game designs are copyrighted. But there's another question, and that is, should you register the copyright? And that is actually quite a complicated question there. And the answer is that if you might. And so if you are worried about infringement, then registering your copyright in the US gives you much, much more power when it comes to enforcing your copyright. And so we had a client recently create a little video and then find this video all over the internet that someone else had shared. And so she asked me to do a DMCA takedown, and Meta, Facebook, said, well, can you prove that it's your copyright? And a registration is a really good way to prove that. And so I would suggest you probably don't want to start copywriting on day one, but this is one of those things early in your launch you're probably going to want to look at. We don't typically copyright source code simply because it tends to change so much. So then, is copying game ideas okay? You cannot copyright ideas. I'm sorry, is copying game ideas okay? Okay, you cannot copyright game ideas. And so there is another question coming up that's going to talk about a similar thing. So you're going to hear an answer twice to two different questions. And that is that one of the other forms of intellectual property besides copyright and patents is trademark. And there are some kinds of things that are so closely associated with a certain brand that they have a trademark on it. And if you copy it too similarly, then you might be infringing on their trademark. And so, for example, if you were going to create a game with a slingshot where you fling birds at houses, you might run into a trademark issue. You probably are not going to run into a patent issue. You're probably not going to run into a copyright issue, but you might run into a trademark issue.
That's fascinating. I've never thought of game mechanics as being a trademark issue. I guess because it's so, sticky to Angry Birds and that whole company that it becomes really the core of what they're doing.
And there is a way that you can change it enough that you can avoid trademark infringement. And this is a thorny issue, and that is that a trademark is built on the idea of confusing similarity. And so when two things are similar enough that people get confused by it, then you run into trademark problems.
Gotcha. Now, you already pretty much answered the question. What sort of business structure would you recommend for small teams working on games? I feel like you might have answered that with the LLC incorporation thing.
I think so, yeah.
Okay. Well, let's jump to the next one then. When should NDAs be used?
Okay, so let me just give a couple of scenarios about when you would want to use an NDA. So imagine this. Imagine that you've got a great idea and you've done a little market research and you believe that this idea is going to generate millions of dollars. So you want to go raise some money so that you can take it from idea to reality. You start hitting up investors, and your natural inclination is going to be to get them to sign an NDA. It ain't happening. The investors are not going to do it because these investors probably hear 10 ideas a day, and so if they say yes to somebody in the morning, and then in the afternoon or the next day someone else pitches a similar idea, they're not gonna want to be able to have to give up on the first one, and so they're not going to sign NDAs. Likewise, if you're talking to your accountant or your attorney, you are probably not going to need an NDA for that, because these are people who are already covered by an ethical duty to protect your interests. Likewise, if you have a fiduciary, you're probably not going to need it. However, there is another. I told you there's three. I just told you three different types of intellectual property: trademark, patent, copyright. The fourth one is trade secrets. And a trade secret is your secret sauce. It's your unique and special way of doing things. And the way you don't register your trade secrets, because that would be silly. If you said, well, here's my secret recipe for my pizza sauce, if you had to register it, then everybody would have your secret recipe. So instead, what you have to do is you have to prove that you've done things to keep your secret sauce secret. And so that would mean that your employees, for example, should have signed a confidentiality agreement. Your business partners that are working for you, if they're contractors, for example, they should sign NDAs to keep confidentiality, because you're going to want to make sure that that you have taken commercially reasonable steps to protect the privacy, so that if in the future somebody takes your idea, you can say, hey, you can't do that. That's a trade secret. And that gives you a lot of power. Now, Apple is famous for being very secretive, and they announced this feature a year ago. I think it was when the iPhone 14 launched, called the Dynamic Island. And so, the little cutout at the top of the phone where the camera is, well, theirs grows and shrinks, and they show little icons and data up there. And it just took everyone by surprise. Nobody predicted this. And as it turns out, they actually had a trademark that day for Dynamic Island. And normally trademarks are filed months in advance. And so usually if you file a trademark, people know. Well, Apple had filed a trademark in Jamaica, where the trademark filing process is paper. And so you can't just subscribe to notifications on the Jamaican website and get alerts every time somebody files a trademark. So they did that. And because of international treaties, trademarks were protected across the world. And so once it was done in Jamaica, then it was easy to also do it in America, in Canada, and other places. And so I'm just going to bet that there was some heavy duty NDAs all over the place for stuff like that. Apple has a competitive advantage of launching something, because if it's software, right, a couple people that are talented can probably stay up late and launch it the next day, and they didn't want that to happen. So that's another example of when you want an NDA, is when even buying yourself a couple days privacy is enough to make a difference. And so you can go online and find NDA templates. You can ask ChatGPT for NDA templates, but if it really matters, you're probably going to want to have an attorney draw that up, because you're going to want to make sure that if someone breaches the NDA, you've got some muscle that you can use to recover.
Awesome. That's great to hear. Now, I'd like to remind everybody, I'd like to just say, basically, Matthew didn't ask for anything to come here or anything like that. He's here to primarily help people. I hired him because I felt like he was one of the few lawyers I was speaking to, unfortunately, that was really passionate about what he was doing it for the sake of doing it. He really wants to help as many people as possible. But I want to give you an opportunity here. If you want to just share a link that people can get to know you, or just, people can put this in their list of contacts and say, okay, if I need some help, here's a guy,
Well, I'll tell you what, I'll drop my YouTube into the chat, because right now I take all of these AMAs and I break them off into individual videos. And so if you want to see my other things that I'm doing, that's the way to do it. And my personal account, I'm verified, but on my business account, I've only got like 75 subs. So hey, boost some numbers. That'd be nice.
All right, jump in, guys, and let's give them a little boost as a thank you.
What do you think? Should we do the next one?
Let's go for it. All right, so let me catch up to where I am. Oh, this is the one I really wanted to get to. Let me pop in. What do I do if someone steals my actual game code?
Yeah, this is, you're not going to like it. And that is that you're going to need to have a lawyer involved. And so the typical process is this. First of all, we start with a nasty letter. And so we send a demand letter or a cease and desist letter, depending on the right context. And that basically is a letter from attorneys saying, this is what we need you to do right now. And if you don't, we're going to initiate a lawsuit. They're easy to ignore. A lot of people panic. And so we do see them successful a fair amount of the time. But also, too, a lot of people, maybe they're not in a position where they can do that what's demanded, or maybe they just don't care. Maybe they think that it's never actually going to come to fruition. And unfortunately, sometimes it is not worth it to bring it to fruition. So in my area of the USA, if you have a lawsuit that is more than $6,500 in damages, then you have to go to standard big boy court. Or big girl court, depending on whichever one is best for you. And the fee to get in with an attorney and everything is probably start at about $15,000. You are not likely to get a lot of relief DIYing it or by spending a little bit. You're going to have to fight, and unfortunately, the system is kind of stacked against people who try to DIY it. And so there's this window of what I call the $15,000 to $50,000 window where it's hard to get relief. And so if you've got what's kind of a minor issue and you say, well, you know what, it's costing me, I spent 25 grand on that, then you might find that you have to just move on. It's definitely worth talking to a lawyer. You can usually find a lawyer who will give you a free or very low cost consult to talk about your options. And so I would suggest doing that right away. But that said, with software source code, you do actually have a little bit more power than you might, because what you can do, first of all, is you simultaneously send a cease and desist and register the copyright. Registering a copyright takes about 2 or 3 months, not a terribly long time, and it's not very expensive either. At that point, then any future infringements, and we're getting kind of, I don't want to get into too much specifics, but you can then enforce your rights using U.S. federal law. And a lot of people outside of the U.S. still prefer to do this in the U.S. because U.S. law is more favorable to plaintiffs, people who start the lawsuit. And there are what we call statutory damages. If you've registered your copyright, then you can get damages of $75,000 per infringement, or there's different amounts depending on what you're doing. And so that might be enough to get a lawyer to take your case. But it can be an uphill battle. And I'll just tell you, a way that this happens sometimes is that we see people use open source software without doing the proper steps. So for example, if there is a cool library, the physics library that was used by Angry Birds actually is an open source library. And I believe it was under an MIT or BSD license, at least the version 1 version of Angry Birds. And so one of the things that you must do if you're using a code that's Apache license or MIT license or BSD license is you must give them credit. And so let's say that I used a physics engine that was released under the Apache 2 license in my game. Someone should be able to go to the About screen and click open source licenses and see, oh, look, they used my physics library. Great. If they don't, then what you can do is you can say, well, you didn't follow the terms of the license. It says you have to give me attribution, so we're going to revoke the license. Now the game developer is using unlicensed software. And I say this not because I think you guys are probably creating open source software, but a lot of small game devs use open source software without giving the proper attributions. So this is actually a risk area. So if you're using, I think a lot of .NET devs in this channel, right?
Yeah.
Okay, so if you're using NuGet to grab code from open source repositories and you do a license check and it says MIT or BSD or whatever, then you have to just have a little about screen where you can say, by the way, I'm using this library. Here's a link, and share it. Some licenses have more strict requirements, so you should do that. And if you want inspiration, go check the Instagram app. And if you go into settings and then about, you'll see there's open source licenses, and there's like 100 different things in there. They do it right. And I actually know the lawyer who was in charge of that, and he's a good guy and really helps people do things right. So the Instagram app is an excellent example for that.
Awesome. Okay, so let's just go ahead and tell everybody, if you guys want to be part of this, you're free to type your questions in. We're going to prioritize audience questions, so just type them in there, and we'll go ahead and answer. And don't feel like there's dumb questions here. Anything that's confusing you, just go ahead and ask it.
Yes.
We want to welcome you to go ahead and just get all the help you need. It actually helps, us form what's being said according to the greatest need, and that's what Matthew would like to do. So,
can I ask a question?
Meantime,
are we all native English speakers here? I just realized I'm talking kind of fast, and if we've got people who don't speak English natively, I can slow down. Just let me know.
Good. Let me go ahead and ask. I'll put this as a thumbs up and a thumbs down. Feel free, guys. Give us a thumbs up and thumbs down, and let us know if we can slow it down. If that helps, you can let us know. But if it's good, you can just go ahead and go for it.
Okay, great. Thank you.
And by the way, anybody who wants to speak, you're also feel free. You can raise your hand and speak. We'd love to have you. So both of those, you're welcome to type your questions and actually speak on stage for the brave ones of you. Okay.
Let's go and do the next one while we get a couple. I see there's some typing, so we can probably do one in the interim.
Okay, let me just lost my place here. If I buy, okay, all right. So this one was for me. So let me contextualize this one. All right. So I've seen that there are all these assets on these asset stores which are actually stolen. Right now they'll have. There was a famous one where there's this music pack from all the Lion of the Jungle and all the animals, right? And it's there for $5 put on by somebody with no background. He's definitely gone up to a bear and a lion with a microphone done this. But people are buying this and then thinking, well, now I have all these rights. And I thought this would be a helpful question for a lot of people here. What do you do in this sort of case if you're caught with this problem, and can you be in trouble even if you bought it?
Yeah, okay, so if I buy assets from a store and they turn out to be stolen, can I get in trouble? Yes, you can. Yes, you can. So if you infringe someone else's copyright, your infringement counts against you. Now, if you are facilitating infringement, then of course you're going to face stricter, stronger penalties. But I think it was a website, was it Pixabay, if I remember right, when they first launched, it was download images for free, but you had to upload images, and people were uploading all kinds of stuff they found on the internet. And so these kinds of sites are extremely unfortunate common. Now, I'll also say too that there are traps. Now, if you are using something in a commercial way that is infringing, you're going to have more problems than someone who is using it for non-commercial purposes. But what I've seen is I've seen people who take pictures, photos, register the copyrights, put them on the website with no copyright statement, nothing, and then they wait for people to use them. They do reverse image searches, and then when they see businesses using them, they sue them and they win.
Oh, that's brutal.
Yeah. And so the settlements for those usually $7,000 to $12,000. And so if you get the letter that says, hey, we found you're infringing our copyright, please don't blow that off. You want to hear the sneakiest one?
Okay.
Apple and Google's and Samsung's emoji are copyrighted graphics. And so if you're using, just for example, Apple emoji in your app, then you are probably infringing Apple's copyright. Yeah, so that's why Discord, you see their emojis are platform independent emojis, and that's because they're they don't have a right to use the Apple ones. Now, don't get me wrong, if you're typing on your iPhone keyboard or Android keyboard and use it, that's not infringement. But if you screenshot all of the emojis and then bring them into your game as assets, that is infringement.
Gotcha. Okay, we have a brave soul willing to come on here. Give me a second to put this on pause because it's going to change a lot of things. Go ahead, and we have invited you there, Chiz. You're welcome.
Hello.
Welcome. Thanks for jumping in.
Hello.
Thank you so much, Matthew. Thank you so much for explaining all of these things to us. I do have a question about, and thank you so much, Samuel, for bringing that in. I have a question about Stripe Atlas and Clerky. Have you ever heard of anybody using them, or do you have any recommendations?
I don't actually know those services. You have to tell me more.
Ooh, okay. So if you're starting an LLC, Clerky and Stripe Atlas, they compete with each other. They pretty much do all your paperwork for you.
Okay.
So, but there's like a monthly fee, and then you can, get a registered agent and all of that stuff, and they pretty much take care of all your paperwork for you.
So another couple brands that do that would be like LegalZoom and Rocket Lawyer. And so, yes, I do know about those services. I will say that I am actually preparing to launch my own service similar to that. Yes. And the reason why I want to do it is because, first of all, a few things. Many of these services do not give you a lawyer. And so you're using templates and you don't actually get any advice. And I think that we can do better. And then second of all, I just lost it. A lot of early stage startups, they just can't afford to have one-on-one time with me. And I'll just say that I live in a very affordable legal market in the US, and my rate and the standard rate in my area is $300 an hour. A lot of people would say, "Oh, can we keep it under 6 minutes?" So I'm always looking for ways to bring the cost of getting legal representation down. And so that's why I'm working on creating a brand that uses my software development background to create automations that streamline our processes. But I'll just tell you, here's the downside to using any service like that, including the one that I'm working on. And that is that some of the decisions we make early in the process are very impactful and can be difficult to change later on. And so if we say, okay, this is a low risk business, and I'll just give an example. If you're a consultant and you are primarily working for 1, 2, 3, 4, 5 clients, and then you've got a very low risk business, you might want the LLC just to have separation between personal and business stuff, but you're not really looking at it for that wall of protection, that limited liability. And so in those situations, I think that it's great. It's fine. If you are in a situation where you have a little bit more legal risk exposure, or even other kinds of risk exposure, financial, for example, it's probably worth upgrading to a plan where you at least get a meeting with an attorney. And so I'll just tell you, this was a big surprise to me. I didn't know this before law school. In law school, we don't actually study that many laws. And this is true even in Canada. We don't go through and read books of laws. What we do is we do issue spotting. And so the professors will give us these scenarios. This, a person buys a 1972 Camaro and they're driving 30 miles over the speed limit and they pull into a parking lot and the parking lot's icy, and they give us these really elaborate, crazy stories. Now list all of the things that are legal problems. And so what lawyers learn in law school is how to spot potential legal issues. And then we do that largely by reading lawsuits. And so if you've got a little bit of a higher risk business, by meeting with an attorney, you're going to tell them, well, here's my idea. And every moment that you're talking, the attorney's gears are making a list. Okay, I found this issue. I found this issue. Okay, this is one that we'll have to be careful of. And so they're going through and finding all of the possible issues. And so when they create a LLC for you, then what they're hopefully doing, and not all do this, but what they're hopefully doing is they're creating a customized plan that builds that really flexible business structure around the kinds of risks that your business is going to face. So I don't know if that went beyond answering your question, but that's the difference between talking to an attorney and using a service. And so that's why I also said you might want to defer some of the legal work until you are closer to launch, because I see a lot of people, you guys are creative, intelligent, bright people. You probably have like 50 ideas. If I said, okay, go write down 50 game ideas right now, you guys could probably come up with 50 original ideas. Out of 10 of you doing that, 500 ideas written down, 496 of them are going to be no chance of commercial success. But 4 of them, they could be good. So you would not want to go through all that legal work on the 496 that are just going to get thrown away. So when you get closer to launch, you start to analyze, you know what, I think we got something here. It's got a chance. It's worth spending a little bit of money now to go do it right. So that's my opinion on it.
From a marketing standpoint, like I think you're really right about what you said there. And you can, if you put little bits about your game out there, which you should be doing if you're making anything, right? You can tell what the audience is saying, right? Like I actually do this for fun, as I take different people's games and I put them out there, and I kind of just see the audience's responses, and you can clearly see the difference with very few tools. You can see, okay, people are dying for this product. Then okay, we don't want money problems, and I assume that would be a good time to, come up with an LLC or an incorporation.
And if we just think about it from a risk perspective, when am I going to start incurring risks? Not when you guys are hammering away on the keyboard. It's probably when you're about ready to release it to the world.
Yeah, absolutely. Great question. Thank you. Appreciate you coming on and appreciate your bravery.
Thanks.
Thank you so much. Appreciate you. Appreciate you as well. Thank you.
Yep. Anybody else who wants to come on, feel free. We're open, and you just do a little request, and you're able to speak and have a two-way if you want to, whatever way you want to go about it. In the meantime, as requests may come in, I will go ahead and continue with the place where we were at, and I'm going to continue my bit of the recording here. Okay. The next question we have is, are legal, putting a rating on your game, is it a legal requirement?
Sure. So first of all, I'll just say this. Now, I have to confess that I am not up to speed on the latest changes. But if you are in a country that uses the MPAA movie ratings, then you might know, like rated G, PG, PG-13, rated R. You actually have to have permission to use those. And so, yeah, it's actually a brand thing. It's kind of like Apple has the MFI, sorry, made for iPhone, whatever, cables or cases or whatever. You have to license that from Apple to put the MFI logo on your product. And that means that you've probably done something to be certified. And it's the same thing to have those is it MPAA or MPRA? I can't remember now. But the PG-13 label, having that means that you are a member of this platform, that you've analyzed or submitted to analysis your content, and that they have said, okay, this is what it is. It's a PG-13. And so first of all, you may not be able to use some of those labels. And I say that my information is not up to date because, a couple years ago, a new brand of labels was put out for non-motion picture. So the MPAA or MPRA stands for motion picture. And so so I don't know about the new standards. But likewise, game devs have rated T for teen and such like that. I'm going to guess that those labels are also part of a membership association that you need. And so if they are required, they are usually going to be required at the contract level with the publishing platform and not a legal requirement. And I do not know that for sure in every country, but my prediction is that those labels are mandated by the platform. So if you're going to release on Netflix, they might require you to go through the certification process to get the label. If you're going to be selling your game at Walmart, same thing. Steam, I don't think Steam has a requirement. They probably have checkboxes. Does your game include this? Does your game include that? And so they're going to require you to be honest and accurate when you check the boxes. I've never published a game on Steam before, but I do not believe that Steam is going to have those mandates at the, that to use the rated T and such. They probably have their own system. Apple has their own system for games that you release on Apple's platform. So the answer is it is not a legal requirement. It is a contractual requirement. So your contract with your publishing platform will require it, not the government.
Awesome. And we have one more question, or a questioner I should bring up. Let me go ahead and bring you here. All right. I think I pushed the right button. Welcome. Thanks for joining us.
Hey.
Absolutely. Can you hear me?
Yes.
Yeah, we can hear you good.
Yeah, I was just going to chime in on game ratings. The ESRB, really the only time you actually have to get certified is when the ESRB is in stores. It's not required for anything that's online. International ratings could be a little different, but I think they all follow similar rules. And you're right, it's not a legal requirement, except when you are in stores. They're the ones that actually require it.
Okay, and again, that wouldn't be legal. That would be a contract. This is the stakes to get your foot in the door, kind of like paying a door fee at a club or something.
Exactly.
Thanks.
Awesome. Thank you for sharing. Do you have a question?
No, I just wanted to chime in on the ESRB. I know quite a bit about them, so if I was just chiming in for the American folks.
Excellent.
Thank you so much. Appreciate that. Okay, let's move on to the next question here.
We've got one in the chat box there.
What?
We got one in the
Okay.
yeah.
All right, I'll read it out here. 3, 2, 1. All right. If, as an indie developer, I started working on a game using lots of different software tools for which I didn't have a license and eventually hit the jackpot with my game, is there a way to handle buying all the necessary licenses to avoid legal issues? If I want to make things right, does timing matter at all, or will I get in trouble in any way?
Okay, this is a great question. So, so let's just say that you use the non-commercial version of your development platform, and then you decide to launch, go live, and then you realize, well, you know what? Now I'm commercial. Do you need to go back in time? And I'm going to say that technically, yes, you probably do. However, practically speaking, I just can't imagine very many platforms even enabling that. The insurance industry does have this concept, though. And so I have had a client come in once and said, I just got audited for my insurance, and they said I didn't have enough coverage, and now they want me to pay $50,000. Well, it is possible that you can get audited in the insurance business and then be made to pay back fees for that. Likewise, in America, there is an organization called the BSA, and they help large enterprise software companies enforce their licensing requirements. And so they also do audits on businesses to see if businesses are compliant. And then they will actually say, okay, we're going to file a lawsuit against you because you're using 900 licenses of this, but you've only bought 600 licenses. But if you want to make it right, you can pay this amount. And so the BSA will do that. And the fact is that if you don't have a lot of licenses that you're going to be paying for, you're almost never going to find anyone who wants to deal with this. And so my suggestion is, if you have started to have commercial success with your product, buy the licenses and get compliant as of whatever date you can, and then stay compliant going forward. And so, like I said, you can't call JetBrains and say, yeah, can I get a license for the last 3 years of IntelliJ? I mean, you can try, and it might technically be the right thing to do, but again, like if you're not buying 100 licenses, you're probably not going to get anyone who cares.
Gotcha. All right. So we have the next question here. What happens if my game team goes bankrupt? Is my game dead forever?
So bankrupt is a special legal term. And so some people use it frivolously to basically say we're shutting our doors, but maybe not actually going through the bankruptcy process. And so let's just talk a little bit about what happens when your business shuts down. So if you cease operations, then let's just say that you've got an LLC or corporation, you're going to want to notify the state that you're in or province that you are going into dissolution. And then at that point, you need to dispose of any assets, pay any bills, and then cease operations. And so for most small indie businesses, there's going to be zero assets, or technically, I'm going to come to this in a second, there's going to be assets, but there's not going to be anything they can really liquidate. And so, for example, you're not going to be able to sell the furniture. There's just no furniture. Likewise, you probably aren't going to have any bills. So you're probably not paying rent. And so if you have any licenses, you're just going to end the licenses and stop doing that. And then you're going to cease operations and shut down. But here's the thing, your business does have intellectual property. And I encourage businesses to register their IP to the extent possible, just in case this day comes. And so, for example, let's just say that you come up with a really clever idea for doing a physics engine. And so if you develop it and either copyright it or patent it or both, then what happens is if you shut your doors, you might find another company who will pay you to take over ownership, or that you can assign this intellectual property to. So when I worked at Google, one of the things that we did was my team helped with mergers and acquisitions. And so Google would frequently buy companies in order to get access to a patent portfolio or something else like that. And so you might, in Amazon, many of these companies, they buy businesses just for a patent or something. And they want to build up these portfolios of intellectual property. So you might find that you actually do have an asset. Maybe you are a designer and your game kind of stinks, but the graphics are amazing. Well, you might be able to actually make some money by licensing out the graphics. So I would say that most companies in this situation will find that they actually do have some asset that they can liquidate.
Awesome. Okay, so we have another question here, and it's a fascinating one because I heard there was something like this that happened where a small group of people put out a game, and it apparently had one single word from like a 3-word title that was in another game, and that game company made them in trouble. So this person, I think, is alluding to that. Can I use part of the name of my game in my game title, like Mine and Dig, rather than Minecraft? Is that an issue?
Sure. Okay, so I'm just going to say it again. Can I use part of another company's game name or trademark in my name? Yeah. And so I kind of alluded to this in previous questions, and the answer is that the secret legal language we're looking for is confusing similarities. And so, for example, if I make a tractor and I paint it green and yellow, but I don't call it a John Deere, will I confuse people? And John Deere almost certainly will argue, yes, you are confusing consumers. You're getting benefit by associating with our brand, and you can guarantee a cease and desist letter at your door. Minecraft, owned by Microsoft, Mojang, which is owned by Microsoft, very, very well could be protective of names that have these kinds of confusing similarities in there. So when you hear people being overly aggressive, and if I remember right, it was Monster Soda did this. They sued somebody because their can had like claw marks on it, which is, the M in Monster is 3 claw marks.
Yeah.
And this can had like 4 claw marks that went sideways through it. And so they sued because they're like, hey, this is confusingly similar. They won, actually. But I would have not predicted that. I would have said this is too close to call. I would not have guessed at the outset whether they would have won or not. Because that is a little, in my mind, a little bit of a stretch. And so when you're on the borderline, kind of like the question asker brought up in this example,
yeah,
then really it's going to be a battle of whose lawyers are better.
Yeah.
And then, but oftentimes, if you can distance yourself from the other product, then you could probably be safe. So, for example, if you are making a Dig Dug clone, which is a game from like the early 90s or 80s, if you were making a Dig Dug game and you called it Mine and Dig, you would probably be safe from Minecraft, maybe not from Atari or whoever made Dig Dug, but you would probably be safe from Minecraft because it would probably not be confusingly similar. But again, that would be borderline, so that would be a battle of whose lawyer is better.
So it's almost like the content itself, the game itself, makes a difference here.
it's going to be the whole thing, right? Like I can paint my car green and yellow and not worry about a trademark complaint from John Deere. But if I paint my tractor green and yellow, then I'm gonna. And for example, dumpsters are also green and yellow in America if they're owned by uh, Waste Management. They also have a similar brand color. So if I paint my trash can green and yellow, I might get sued for that.
Well, didn't expect that one. All right. Okay, if I find assets online for free, can I use them in my game?
Okay, excellent. And this is not too far different from another question, but these are things that developers really think about. And I'll tell you, I know one developer who I think is kind of like a coder, a music developer, a graphic designer, gaming. Like there's like out of 100 people that I know that are great developers, like this person's got all the skills, right? That's so rare. Usually
Yeah.
a person's, like they've got an idea for mechanics, but they can't code anything, right? And so they describe it to a developer, and then neither one of them can make the audio sound good, right? And so they have another person who does the clicks that come in just right. Okay, great. So you're always trying to find assets. And if you are rushing to market and you're a coder, what are you going to do? You're going to find assets that someone else made. So if you find it on the internet and there is not a license that permits you to use it, don't use it. Don't use it. In copyright law, oops, do I have the wrong one on my screen?
I think you do, but because I said
Yeah,
the wrong one.
No problem. Okay.
Okay.
That's fine. So the rule of thumb in copyright law is if in doubt, ask for permission. If in doubt, ask for permission. You will often find that a lot of people create things out of a desire to share. And so my time in the open source world, I found that altruism is a huge, huge driver for people who make contributions. And if you find a developer or a designer who's done something cool, and you say, hey, these icons are great, can I use them in my game? They might be flattered. And they might say, sure, just give me credit in the thing or whatever, and then do that. Because now what you're doing is getting a license. By the way, try to get it in writing, please. So if it's a Discord chat, say, hey, can I email you just to get something in writing? Send them an email saying, hey, I found these assets. You said I could use it. As long as I do this, does that sound good? They reply, yep, great, good, do that. But don't use it without permission. Permission can be a license, like an open source license, or it could be a conversation.
Awesome. Okay, so let me jump to the next one here. Well, should I cover the last one, or did we cover it well enough with the earlier one? Because I feel like
No,
kind of
let's go ahead and do it.
Let's go for it.
Yeah.
Okay. Can I make a fan game of my favorite title? If not, how can I allude to other titles in my game?
Okay. Can I make a fan game? So fan art is a well-discussed concept. Fan art is a derivative product. And so, all right, I'm just going to tell you, I like YA fiction. I know I'm in my 40s and I shouldn't be reading stuff written for teens, but I think teenage problems are way more interesting than adult problems. And so I would rather read about teenage problems every day. There was this really cool book. It was called Fangirl. And yes, I know, I'm not afraid to say it. And in that book, this girl, she went to college, and for one of her papers, she turned in some fanfic that she wrote, and she got slapped on the wrist for spoiler alert, hashtag spoiler alert. She got slapped on the wrist for what's the term that they use in plagiarism. So fanfic, fan art is a derivative product. And so what you're doing is you're taking someone else's creation, you are then modifying it, and the end result has a copyright that is shared by both parties. So the originator has copyright, and the derivative creator also has copyright. And so, so can I make a fan game of my favorite title? And the answer is, if you're going to do it for commercial purposes, you are probably exposing yourself to legal risk. So I urge great caution. And then next, just realize that you might not be able to distribute your stuff simply because you are creating a derivative product. And especially if you're going in the commercial world, you expose yourself to pretty great liability. So I would say use caution. But what kind of intellectual property rights are you infringing? Because if you're doing something, you're talking about infringing someone's rights. You might be infringing their copyright, which means their idea has been expressed and converted into some kind of fixed form, and now you've taken it and modified it. Okay, okay, that's fine. Or maybe their trademark, maybe there's some mechanic that is really, really unique, and that people always think of this, the game, the Angry Birds example from before. Okay, well, now you've taken and created something that's, that's possibly copyrightable. Or maybe you looked at their source code and you recreated something that is very similar, but because you looked at it, your new code is a derivative product. So, so those are things where, yeah, you're in trouble. Well, what if you heard some idea on the radio and it gave you a new idea that's different? Well, that might not be a derivative product because there might not actually be intellectual property to infringe. And so it's kind of tricky. But you know what? Try to be as creative as possible. That said, everyone's first project is pretty much always a recreation of something else, right? How many people, their first game was a Flappy Bird clone? It's like you can do it in a couple hours. And so it's the way the world turns. and so it's going to happen.
Yep.
But before you go commercial with something, just use caution if you are creating a derivative.
Awesome. All right. So the next one here is, should I copyright my game?
Should I copyright my game? It's so hard. It's so hard. What are you going to copyright? Should you copyright your graphics? Well, the moment you created them, you did get a copyright. So should you pay money to register your copyright for your graphics? If you're worried about infringement, then the registration gives you a lot of power to stop people who are infringing, and to even get money from them if they're using it for commercial purposes. So, so if you are worried about people stealing your graphics or whatever, yes. Now, what about story? Okay, if you've written the story down and someone copies your story, you've got a copyright on it. So should you register your copyright? Once again, if you're worried about someone stealing your story, fine. Game mechanics, if you've got this really clever new way of doing things that you've invented, should you patent it? Well, if you think a patent's going to cost you a few $1,000s, if you think it's going to make you that much money, then I think you should probably do that, because that way it's easier for you to make money if you do have to close your business, and then also easier for you to protect your thing if you hit it big. For most purposes, though, I'm going to say it's usually not worth it. Definitely not source code. Don't go registering the copyright to your source code unless you've got someone infringing and you need to stop them. Instead, just use privacy to protect your stuff. Trade secrets. Make your contractors and business partners or team sign NDAs to keep things commercially secret. Commercially reasonable measures to keep things secret. I would say use privacy as your primary defense and offense.
Cool. Awesome. Now we have, I think, one of the biggest questions of the day. What if I use AI art in my game? Is that an issue?
Sure. Great question.
It's a broad question.
Yeah. What if I use AI art in my material that I make? Okay. The question is that this has still not been decided by a court yet, and so there is a huge amount of uncertainty. And so when I left the team at Google, this was just coming onto our radar. And you know what they say, opinions are like assholes, right? Everyone's got one. There's just so much uncertainty. There's so much fear. There's so much doubt that it's really hard to know the answer. And so here's what we do know: that something that is original and created by AI cannot be protected by copyright. Not in the US, and so far not in any other country. Most countries limit copyright to humans. Only humans are allowed to have copyright. And I know this is weird, but businesses are often considered people too, and so businesses can have copyright. And so that if you do it, then you're not going to be able to protect it at the very least. Someone can steal your graphics, and it is what it is. You can't stop them. And so you wouldn't want to use AI to make your logo because that would be very difficult to protect. But here's the thing, we are seeing AIs regurgitating material that was created by other people. There was a hack that was announced earlier in December where someone said to ChatGPT, write the word poem 999 times. And after like 400 times, it started spitting out people's personal data. And so it was like people's name, address, phone number, stuff like that in the word poem. You see poem, Dr. Schmitz, address 202, all these different things. And so what happens is sometimes the AIs just randomly spit out something that was made by someone else. So can you be sure that the things that were created by AI are original? And the answer is no. Even the people who make the AIs, they don't know how it works. I was reading this article where these researchers were trying to figure out why was AI making mistakes. And there was a picture of it was a German Shepherd or a Husky dog, and the AI had said it was a wolf. And if you've seen these kinds of animals, they have a lot of similarities. And so they were curious, why did the AI think that this was a picture of a wolf? And when they figured out how to make the AI tell them, the AI highlighted the part of the image that it used to make a decision. There was snow in the background. And because there was snow in the background, the AI thought, okay, well, this is a wolf, not a husky. Okay, well, that's like crazy. That's like a really weird reason to make a decision. But AI is doing this. It's making decisions based off kind of crazy, wacky data. We don't understand it yet. And so sometimes it gives you stuff that might be infringing on someone else's copyright. The classic example, Armin from, I can't remember, somewhere in Eastern Europe, he told, what's GitHub's? Copilot. He told Copilot to write a game, and he typed in the first few letters of a piece of code that he knew was present in the Quake source code, and then he hit tab, and Copilot generated function exactly from the Quake source code, including the original developer's swear words, because the original developer had sweared in the comments like, oh, this stupid, piece of whatever, and it came out exactly right. And they were like, okay, well, boy, sure looks like it's copyrighted material. So is it an issue? It's kind of an issue.
All right, guys, this is your last chance. If you want to get some questions under the door, slide them in there. We're going to answer the last one in the meantime, as you guys have a moment to type here. Can I use name brands in my game?
So many brands would prefer you not. They want to have control over the associations between their brands. So can you use their brand name in your game? And the answer is probably not. So I'm sure you guys know the story. There's a game developer that made a game where someone gets trapped in a furniture store that looks remarkably like IKEA, and they have to find their way out of, what game I'm talking about? I can't remember the name of it. And IKEA said, can you please stop? And IKEA actually was very polite about it, which I think is notable for a major brand. But they're like, this is clearly our trademark. You're using it in a way that we don't approve of.
Yeah.
And so so the answer is I would say avoid it. Now I'll give you an exception. The answer is avoid using other people's trademarks. Now, U.S. law, one of the things that we use as a very valuable resource is FTC, Federal Trade Commission opinions. And FTC said, can I use competitors' brands when I am comparing my product to theirs? And FTC says, yes, you can and you should. So so if you're doing it to compare, like, hey, we're even better than Minecraft. Well, that's going to be okay. Now, if you've copied Minecraft, that's not going to be okay. But like, can Terraria say it's like Minecraft but 2D? Yep, they can do that. Absolutely, that's fine. Can you see a Minecraft logo in Terraria? Well, I don't know why they would want that, but the answer is that's going to probably get Mojang on their back. And so remember my statement before when I said, if in doubt about copyright, always, can you guys remember? Ask, always ask. So you can do that with trademarks too.
Awesome. Okay, do you want to give a quick recap of just that one answer that you gave for when a startup is barely beginning and doesn't have upfront capital to set up an LLC? What are the protections?
Sure.
In the interim?
When you're at
the
short one. The short answer is, should you spend the money on an LLC or something early on? And my answer is that when you're in the keyboard warrior phase where you are pre-launch, your risk exposure is low. And so I would say that it is not necessary at an early phase. You should have a discussion with all of the people that you are incorporating to make sure the terms are clear, but then form your business closer to launch. And that way you're not spending money on something that you don't think you're going to profit from. And so if it looks like this is going to come together and you're ready to start launching, or maybe doing more detailed focus group or UX research, that's probably the time to start forming your business. If you're going to be getting investment help, of course, then you're absolutely going to want that kind of a structure. So I would say, look at your risk profile. If you're doing non-risky activities like hammering away at your keyboard, don't waste your money. If you're like, okay, I'm ready to start profiting, not a waste anymore. Spend the money.
Awesome. All right. Well, this has been a fantastic time. Any last comments there that you want to end us off with, Matthew?
Well, hey, I really appreciate everyone asking questions in advance and even in the discussions. A lot of times when I do these, I don't have a live audience. It's actually fun knowing people are watching. Please check out my YouTube channel. Don't be confused. Originally, when I launched, I was Iowa Business Lawyer, but I've outgrown Iowa, and so we are now Surge Business Law. And so a lot of our stuff says Surge Business Law. Look us up on YouTube. I do break out each question separately and make it a separate video, and I'd love for you to see that or share that. There's a question. There's a question in the comments.
All right, let's go for this question. This is a good one. Can you use AI as concept art and then use the art as reference for real art?
I understand the first part. What do you mean by use the art as reference for real art?
What that means is basically you have a concept, right? And then you would go back and say, okay, now I'm going to actually do it by hand and actually do the real thing.
I think that's a great idea. You should do that. You should definitely use AI to make your concept art. And then does everyone here use Git, or do you guys use something else?
In our organization, most people are using Git. So
okay.
Git is very popular.
All right. So I don't know. Forgive me. I kind of stopped developing around the time that Git took off. But in some version control systems, you can tag things so that you can remember to do them later. And so if there's some way that you can tag your graphics so that you can't go live without going back and having a tickler to remind you to swap these out, that would be good. And maybe it's Jenkins, which I'm sure nobody uses Jenkins anymore. But you know, your tools like that would be a good idea, because you wouldn't want to launch with it. I would suggest not launching with that in there. And so if you can have something that prevents you from building a release candidate until it's replaced, that would be good.
Awesome. I'm actually doing this. I asked a 3D artist to create a model out of an AI generated concept art. That's interesting.
Now, I will say that you are introducing a new untested legal question, and that is, you know, is this now a derivative work? And if so, what happened? Who's the other derivative creator? And I can't wait to see how the legal industry answers this question. But I'll tell you this, that usually the commercial world will just go for it, and then the legal world will catch up because the commercial world goes faster. And so it might be that this never really gets tested by law. So
Pseudo is saying, it looks like the direction the law is going is to not allow copyright AI generated material. What are your thoughts on that? Well, so here's the thing, okay? That is correct for now. That is the way that it's going now. Copyright is only granted to human authors. But Simon Willison, he kind of invented this term about a year ago, in fact, called prompt engineering. And are you guys familiar with that term now?
think we probably are getting more common
I've
with
heard
it. Prompt engineering is this idea of developing the skill to get the AI to do what you want. And I'll confess, I use ChatGPT's premium subscription all the time for contract drafting. I don't suggest non-lawyers do it, but I can take what's a 10-hour project and finish it in 90 minutes because I know what I'm looking for, and I can get ChatGPT to write it faster. And so it just saves me a lot of keystrokes. But I have to really work hard to make ChatGPT do what I want. If I just type something simple, it'll give me garbage every time. I once tested having it write a will, and I'm like, oh, please, nobody do this. This would be bad. Um, and so there's this idea that I'm building a skill and a talent that I can tell the AIs to do good things. Okay, so is that something that I can copyright? Can I copyright my prompt? Because those prompts take a lot of creativity. Right now, the word is no. And I think the reason why is for the same reason that tweets can't be copyrighted because they're not long enough. But I can see a point in the future where this idea of prompt engineering is accepted as something that is a creative endeavor worthy of copyright protection. And just for a case in point, for many years, choreography, dance scripting was not copyrightable, but the industry actually created a language called dance notation that allows choreographers to write their choreograph. And then once that happened, the art of dance production was made able to be copyrighted. And so maybe we'll see the same thing with prompt engineering.
That's awesome. It's fascinating to see these things develop in real time, isn't it?
We are in a very interesting time. I can't believe it's just like every once in a while you see a technological innovation that just moves things forward by such a leap. And LLMs, the kinds of AIs that we think of with ChatGPT, man, wow, that was such a industry changing thing. Copilot, right, preceded it slightly. And you remember when Copilot first came out, we're like, what? Are we even going to need programmers anymore? And of course, the answer is yes, but it's fun times.
I agree. Let's see. Here we have somebody else writing. I'll pause for now. Give you a moment. When it comes to art, if you plan on releasing elements, releasing your game on Steam, if it has AI elements, Steam will ask you to remove it. That's correct.
Now,
Steam doesn't allow for it.
I'll just toss out some non-legal advice. I had a manager way back when, and he was a huge believer in processes and systems. And in hindsight, I didn't respect it enough at the time I did it, but I later really gained an appreciation for the benefits of having processes. If you do something right once, it would be good if you could do that right again and again and again. And we do that through processes and systems. And this is the difference between businesses that are successful and businesses that fail. And I know a lot of people are disdainful of Blizzard. Okay, I know. But Blizzard has created many great games. This isn't luck. This isn't luck. They know they've got a recipe, they've got a system for creating great games. And so I love systems and processes. I think that all businesses should have them. And so what's Jenkins? What's the modern version of Jenkins? What is it that people use nowadays? It's this thing that it checks before you check in your code, it builds it, runs your tests, does all of that. Oh, someone says it's Jenkins. Okay. And so there are ways that you can tell your build tool to not let you do things until XYZ have happened. And so if you can create systems that your automated tools use and force to happen, that would be great. And so if you're using AI elements in your game, you're like, okay, don't let me do a 1.0 build until those things are gone. That would be a good move.
Awesome. Now, I have a little bit of a question for you, but let me do the outro for this video I'm recording real quick. And just say that I want to thank you guys all so much for coming on, watching and enjoying. Remember, you can reach out to Matthew Nussum. We'll leave a link to his channel down below. That's Surge Business Law. You can just search it up there and join in and take a look. Follow him. Get the questions answered for free that are on your mind, and be there. And if you just want to support him and say thank you, you can also join the channel for that reason. So thank you all for coming. I appreciate you watching this version of it. See you guys next time.
Okay, but everybody stay.
Yes, but everybody stay. That was just my recording. I have a question for you. I've been meaning to ask you because since we talked last time, it's been sitting in my mind, and it has to do with what you were talking about with businesses, right? When businesses fail, you said there's a pattern. When they succeed, there's not necessarily a pattern. And I've been sloshing that around, and I'm trying to make it stick, but I'm not fully getting it. Could you help me?
Yeah, I've said this before, and in fact, I technically have a fellowship with a university to write a book on this, and so one of these days I'm going to get around to it. But the reason we can't study success and get a repeatable pattern as much as we would like, and this is commonly known as survivorship bias. Survivorship bias is that the things that cause a business to succeed or survive are not always skill. They could be luck. And in fact, I would say that there's usually an element of luck. I have seen many talented people have great ideas, and others come along with an idea that might be inferior, but they were at the right place at the right time, and that was what it took. Or here's an example I will use once in a while. When I was in college, we were all mad at floppy disks because you could only put 1.4 megabytes on a floppy disk. It just wasn't enough. And so two companies came out with a competing product. One was called SideQuest. They had an Easy Drive, and it was a very high quality, superior product. Another company named iOmega came out with things called Zip Disks, which is a very cheap product. They were both priced about the same. I think that iOmega won with their zip drive because they had a cool name. It wasn't because they had a superior product. You know, the discs were terribly low quality and failed often, but it was just fun to say. Well, what a silly reason to succeed. So there's an unlimited number of ways to be successful, and I don't want to be discouraging. There's just an unlimited number of ways to be successful. There is a relatively few number of ways to fail. And if you do these things, you're going to fail. And so, for example, a lot of businesses don't profit. Well, guess what? That's not a business. It's a hobby. And so that guarantees failure. There's a finite number of things. If you do it, failure is guaranteed. There's just not very many things where if you do this, success is guaranteed. In fact, I can't think of a one.
Really quick, I'm trying to contextualize your question there, heart emoji. Would you like to just, I see, I missed the earlier one. Let me ask the earlier one here. What if a bigger company like P1 were to do this, for example, having volunteers work for a nonprofit company? Would there be risks there? Now, the one problem is you can't give actual legal advice, and I don't know if this is sorting into that.
We can answer in generalities. So there is always risks. There's always risks. And I have a presentation that I give to my new business owners that I always say this: I am a risk management attorney. I am not a risk avoidance attorney. Do not live your life avoiding risks. You cannot walk outside your front door without taking a risk. And you cannot lock yourself in your house without taking a risk. We should embrace risks, but I don't want people to take unreasonable risks. And so we need to think about, okay, what could go wrong and what could go right. And if the benefits outweigh the problems, then we should do that. And so one of the things that we don't think about sometimes is opportunity cost. And so not doing something means we might lose an opportunity. Or if we take option A, we can't do option B anymore. So that's a risk. So make sure to think about that. But I want businesses to take risks. And so there is always risks. It should be done, but calculated risks are better than uncalculated risks. So so is there risks involved with having P1 bring on a nonprofit arm? And I will say this, that yes, and I think I want to avoid going into specifics on that, but I will say that that what should be done is a team of trusted people, decision makers who have influence on it, should get together and maybe get a whiteboard or a Google Doc or something and just kind of brainstorm it. What could go right? What could work? What could go wrong? What could fail? And then make a plan based upon that. And talk to a lawyer.
That's why we talk to you.
Okay.
Really quick, I did have a.
Go ahead.
I did have a thought. I probably do have to go after this one.
Okay.
Again, I want to avoid anything where I put you in a position for legal advice. So please feel free to deny if this is not, if we're not able to be general with this. But this question, I had it before, but I'm trying to understand the reasoning. I feel like something sticks when it's understood in my way of thinking. When it comes to like open source, how do you open source something if there's a lot of vocal contribution that are not written down, or does that not matter because it's not commercial?
The commercial nature doesn't matter. So you do not get copyright protections by it being commercial or not commercial. And so you get copyright protections by putting something into fixed form. And so the counterpoint is jazz musicians. Many jazz musicians improvise. And so if there's any jazz fans in here, that's the beauty of the art. And if there is no recording of that art, then there is no copyright. And so many jazz musicians have found that their creations are used without their permission because they inspired somebody, but there was no fixed form. So verbalizing something is not enough. But if you record it, then it is. However, the copyright is limited to the recording. And so is anyone here a musician? And so I'll just tell you that when it comes to copyright, musicians get screwed. Musician performers get screwed. Music writers are the winners. If you want to make money in music, you need to be a writer, because the performers, their power is limited to the good. Okay, we've got one. Their power is limited to how people use the recording. And so Taylor Swift, so I'm not a Swiftie, but I do have a lot of respect for her as both an artist and a business person, and as a writer. So she makes money on, yes, she makes money on a lot of things when it comes to music because she writes a lot of her stuff and then she performs it. But she recently was in the news because her recording contract granted the masters to some of her music to a person that she didn't like, and that person sold it to someone else. So the recordings of that original music had a copyright, but they couldn't change it. They couldn't. The recordings were the recordings. They couldn't add new stuff to it. And so she was allowed to go make new recordings. That was fine. And so so that was okay. So so if you record your ideas, if you have a meeting and record it, the recording will be copyrighted, but the ideas won't. So so you really have to kind of convert those ideas into some fixed form in order to get the copyright protections. Likewise, patents, same thing. You have to somehow record them. Oh, we must have struck a nerve. Music video, yes, but yeah. Once again, it's the video. So it's kind of interesting. In the 80s, a lot of creative people were sampling music, and so they were using like 1 second of a song, and it was found that those 1 second samples were infringing. And the reality is that was actually kind of good for the original artists because they didn't get money from anything other than the use of their audio recordings. So if you use 1 second, well, they got to make money. If they weren't the writer of the song, that's it. That's correct. New versions are derivative works, and yes, each one can be different. And is Sunny the one that's responsible for that? There is a big controversy on whether or not sampling laws were targeted at the African American community, or the Black community, I should say. And so some people have made some pretty reasonable arguments that these laws were implemented in a way that was biased against Black performers. So we might see that show up in court here before long.
Awesome. I have we have taken lots of your time, so you can call it at any time, but you seem to be in your element, and I have a little extra one for you if you're up for it.
A little bit longer, we can do it.
Okay, so this is a question I've had in my mind, and it has to do with copyright. So I'm a big believer that in the future, we're going to use virtual worlds in a way that we don't today, where most of our communication with others is going to happen in virtual worlds. And all these conversations have really led me to think about that fixed form type thing. Now, if I'm having a conversation with you in a day-to-day conversation, it's not really fixed form. If we're in physical life, we're just talking to each other. It's not fixed form, right? But
right.
Everything you do in a virtual world at some point is going to become fixed form because it's going to be recorded somehow. You're going to leave some sort of element of it after, whether it's a recording that is just constantly happening that you can wind back in time, whatever it might be, the replay that plays of your actual life. And there's going to be multiple people there that you don't have control over their recording abilities and so forth. And therefore, stuff is going to show up in fixed form, and we're going to end up with potential for copyrights of a lot of things. And our current way of dealing with things is that we copyright everything by default. And my thinking is that for virtual worlds not having that, having to actually say this is copyright might be the better way to go, might create a freer society, because when every blade of grass and every image is copyrighted because somebody made the blade of grass, that just leads to so many issues.
Yeah.
It's just more than conceivable,
Well, for most of human history, people who created things did not give very good protection. And so I would say that the pendulum has swung the other direction to be more protecting of original creations. I am actually a fan of copyright, and okay, I'm a copyright lawyer, so maybe that's not too profound. I am a fan of copyright, but here's why. By giving authors protections against their copyright, then what we do is we encourage creativity. And so if doctors don't get paid well, then are they going to go through medical school, or are they going to put their big brains to work in things that are more profitable? And the answer is at least in America, being a doctor is a good way to make money. You tend to make good money, and that's good because you're going to graduate school with $200,000 or $300,000 in debt, and so they need to make it back. And it's hard work. It's 10 years of school, right? And so likewise, creating things is hard work. You guys have amazing brains. You could do all kinds of things with those brains, but because you know that your creations, that you have some rights to them, to commercialize them if you want, then that incentivizes you to do that. And maybe your goal is to simply be generous with your creations, and that's fine because you have the right to do what you want with your creations. Then you're motivated to either commercialize them or donate them or whatever, but there's respect for what you created with your brain. And so I'm a big fan of that. I think that copyright law encourages creation. Your virtual world example is good, though. I'll tell you where I thought you were going to go with that, because there is an issue, and that is that a lot of these virtual worlds have terms of service that grant the host of the world certain kinds of permissions, and that might discourage copyright creators. I think of Minecraft. I play Minecraft with my kids, and I love it. It just allows for so much creativity. I had Legos when I was a kid, and I think Minecraft is the digital version of it, and it just gives people a safe place to do cool things. And then the next version of virtual worlds is the same way. I'm a little disappointed with Roblox, because when Roblox first launched, it was also a creative platform, and now nobody does that. It's just a place to go around and play games, right? And so I think that creators should continue to have rights to their creations in these virtual worlds, but I think what will happen is the terms of service agreements will probably limit those.
Gotcha. I was thinking like you could check a box or something like that if you wanted it, because I imagine that at the low level, there's going to be millions of people just creating stuff for the sake of creating without even knowing. The average person I meet does not know you get copyright when you make something automatically. That's why they think I've got to go to the office and I've got to register this because otherwise I don't get my copyright. My thinking is that having a little checkbox every time you create something, yes, I want to keep it, or no, I want to throw it to the world. Might lead to a foundation where there's a lot of stuff that you can work with, and then you have the rest of creation on top of that, where it's like, okay, this is actually mine. I want to hold on to this a little bit. I don't. Just my thoughts.
If I create a house in Minecraft and somebody copies it, can I sue them?
The ultimate question. Put this one on your YouTube channel.
Yeah. I think I will. I've got a lot of copyright lawyer friends on LinkedIn, so I might put it there.
Okay. Awesome.
I think we should call it a wrap. I'm getting paged by my family, yep. So should we bring this one to an end?
Sounds good.
Okay, so I will. This is Matt Newsom, the attorney, and I just want to remind everybody that you should talk to an attorney to get legal advice. I'm not your lawyer, and so internet information is sketchy sometimes, and it's hard to tell what's good and what's not good. And so if you're making decisions about your business, your rights, your creations, please do get legal counsel. And if you need a business lawyer, you should reach out to me, Matt Newsom with Surge Business Law. I might help you, or I might refer you to someone else, but I'd love to make sure that your business ideas are successful.
Well, I'm just answering a question, and it's been fantastic having you. We normally